Good afternoon to all of us. My name is Angelica MALICDEM. And for today, we are going to talk about kinds of winding up or liquidation. But first, let us review what's the meaning of winding up.
Winding up is the process of dissolving a company. While winding up a company is to do a business as usual. Its sole purpose is to sell off stock, pay off creditors, and distribute of any remaining asset to partners or shareholders. The term is used primarily in Great Britain, where synonymous with the liquidation, which is the process of converting asset to cash. This winding up happened after ng dissolution ng company. Ibig sabihin na kapag imbestiga na, meron ng final decision yung mga partners, and at the same time, meron silang napag-agrihan kung sino yung magko-convert ng money to cash and everything. Winding up has a two kind. One is the extrajudicial. Liquidation is done without the intervention of the court. Means, walang third party involved doon sa pinaka-dissolution ng company. Whatever that happens or how the company or the partnership will end is nasa partnership na yon. They just going to appoint one of the members or one of their partners to do the winding up process. Who will wind up? Number 1, the liquidating partner or partners as agree upon by all the partners. Number 2, the partners who have not wrongly dissolved the partnership. Number 3, the legal representative of the last surviving partner who is not insolvent. It just mean na kung sino lang yung mapagkasunduan nila, siya lang yung gagawa ng winding up process. And hindi pwede mang alam yung ibang partners para walang makagalaw ng ebidensya. The next is the judicial. The liquidation is done under the control and the direction of the court upon the proper cause that is shown to the court. Just mean na meron ng third party involved, which is the court. And yung court, siya yung mag-a-assist or mag-a-appoint ng tao to end up the business or to wind up the business properly. And at the same time, ginagawa yun ng court para masiguradong walang bias and walang ebidensyang magagalaw at malinis yung pagkakatrabaho. Who will wind up? The person appointed by the court. It's mean na hindi pwede mang-alam yung partners involved in a partnership. Kasi yung taong inappoint lang ng court yung pwede gumawa ng winding up. And throughout the process is hindi sila pwedeng makialam. Pwede sila manghingi ng update, magbigay ng suggestion, pero yung final say is manggagaling din sa taong inappoint mismo ng court. Article 1897. When dissolution is caused in any way, except in contravention of the partnership agreement, each partner against his co-partners and all claiming through them in respect of their in the partnership, unless otherwise agreed, may have the partnership property applied to discharge its liabilities, and the surplus applied to pay the net cash amount owing to the prospective partners. But if the dissolution is caused by infraction of the partner bona fide under the partnership agreement, and if the expelled partner is discharged from all partnership liabilities either by payment or agreement under the second paragraph of Article 1835, he shall receive in cash only the net amount due him in the partnership. It just mean na yung taong dahilan ng pagkaka-winding up ng business is siya yung pinaka-mailes na makukuha after ng winding up ng business. After settling all the creditors and yung sumobra dun sa kinita ng company is hindi na siya makikihati pa dun. Wala na siyang magigain, kundi yung income or interest lang nung pinaka-capital na binigay niya sa partnership. Next topic is when the solution is caused in contravention of the partnership agreement, the right of the partner shall be followed as: Number 1, each partner who has not caused dissolution wrongly shall have: A. all the rights specified in the first paragraph of this article, and B. The right as against each partner who has caused the dissolution wrongly to damage for the breach of the agreement. It's mean na wala ng utang na babayaran and may hati pa siya doon sa sobrang pera maliban doon sa interest ng kapital niya. And pwede niya pang kasuhan yung kung sino man yung naging dahilan ng pag-dissolve ng partnership na meron sila. Number 2, the partner who have not caused dissolution wrongly if they decide to continue the business the same name either by themselves or jointly with other may do so during the agreed term of the partnership. For the purpose may possess the partnership property, provided they secure the payment by the bond approved by the court, or pay any partner who has caused the dissolution wrongly the value of his interest in the partnership at the dissolution, less any damage recoverable under the second paragraph. Number 1V of this article, and in the manner of indemnify him against all the present or future partnership liabilities. Means, dun sa mga taong hindi naman nakagawa ng something dun sa partnership is pag gusto nang ituloy yung business, kailangan nila magsabi agad para malaman kung magkano yung damage na babayaran. At the same time, paano malalaman na mai-recover yung mga damages na yun in the future. Right of the partners in the case of liquidation caused by the violation of or non-violation of the partnership contract without contravention or violation of the partnership agreement. Number 1, to have partnership property applied to discharge liabilities of the partnership, and number 2, to have the surplus, if any, applied in cash the net to the prospective partners. It will apply dun sa mga partners na hindi naging cause ng pag-dissolution ng partnership nila. Wala na silang utang, at the same time, meron pa silang dagdag na kita. Contravention or violation of the partnership agreement. Second, right of the partner who has not caused the dissolution wrongly. A. To have partnership property applied to discharge of liabilities of the partnership. To have a surplus in any applied to pay in cash the net amount under the second owning of the respective partners. C. To be indemnified for damages caused by the partners who has caused the dissolution wrongly. And D. To continue the business in the same name either by themselves or jointly with others during the agreed term of the partnership in the purpose of the possess the partnership property. Ibig sabihin, kung hindi naman ikaw yung cause ng dissolution ng partnership nyo, is pwede mo parang ituloy yung partnership na yon using the same asset and property na meron kayo. Number 2, the right of the partner who are wrongly caused the dissolution. A. A business is not continued by the other partners. To have the partnership property applied to discharge the liabilities of the partnership and to receive the cash in share of the surplus less damage caused by his wrongly dissolution. Ibig sabihin, wala na siyang karapatang i-continue yung business nila and wala na siyang karapatan mag-gapol pa sa mga sumobrang kita ng company. Letter B. If the business is continued by the other partners. A. To have a value of his interest in the partnership less damage caused in his co-partners by the dissolution ascertained and paid to him in cash, or the payment is secured by a bond approved by the court. B. To be released from all existing liabilities of the partnership. It's mean na yung capital niya is magkakaroon ng interest and ibibigay sa kanya yung interest na yun. Pero, sa surplus nga, wala na siyang hati or hindi na siya kasali sa hahatian pa. And, hindi na siya kabilang doon sa may utang or sa liabilities na kasama yung in the name of the partnership. Article 1838. When a partnership contracts rescind on the ground of the fraud or misrepresentation of the parties, therefore, the party entitled to rescind is without prejudice to any other right entitled. Number 1, to alien or the right of retention of the surplus of the partnership property after satisfying the partnership liabilities to third person for any sum of the money paid by him or for the purchase of the interest in the partnership and for any capital or advance contributed by him. Number 2, to stand after all liabilities to the to third persons have been satisfied in the place of the creditors or the partnership for any payments made by him in respect of the partnership liabilities, and number 3, to be identified with the person guilty of the fraud or making the representation against all the debts and liabilities of the partnership. It just mean na pag tayo yung may kasalanan kung bakit madidissolve yung company is malaki yung kakaharapan nating kaso. And yung partnership o yung mga partners na may iwan natin is kailangan natin silang tulungan para makabangon sila or maibangon nila yung company na yun and yung partnership na meron sila. The 3 rights of a partner who is entitled to rescind. Number 1, right of liant or right of retention. Number 2, right of subrogation. And number 3, right of indemnification. Right of retention is the right of the creditor to retain a thing which belongs to the debtor, and which is the creditor's possession until the debt has been fully paid. A liant is a legal right to claim security interest in a property provided by the owner of the property to creditors. It is generally used as a guarantee for some sort of legal obligation such as loan repayment. Subrogation is a term describing a right held by the most of the insurance carrier to legally purchase a third party that caused an insurance loss to the insured. This is done in order to recover the amount of claim paid the insurance carrier to insure for the loss. The right of indemnity and the duty of indemnity ordinarily stem for a contractual agreement which is generally protect against liability, loss, or damage.